Afternoon, good evening, good day. Welcome to the last part of our discussion regarding intellectual property law. This will also be the last part of our discussion for copyright. So let us begin our discussion with the limitations regarding copyright. So these bullets and succeeding bullets would be the instances where uh, these acts would not constitute an infringement of copyright. So number one is the reproduction or distribution of published articles or materials in a specialized format exclusively for the use of the blind, visually, and reading impaired persons, provided that such copies and distribution shall be made on a non-profit basis and shall indicate the copyright owner and the date of the original publication. So sinasabi natin dito, if there's a published article or material, 'di ba? 99, I'm not really privy with the details, but if not all, sige, significant number of it has been published for the consumption of some people like us, yung hindi visually impaired, nakakabasa ng maayos. So ngayon, kung magkakaroon ng special format para sa mga bulag and sa mga not necessarily bulag or pwede din sa not necessarily bulag, and for non-profit basis, hindi magkakaroon ng infringement provided also na magkakaroon ng attribution sa original owner and indicated then yung original date of publication. So number 2 would be the citation or performance of work once it has been lawfully made accessible to the public, if done privately and free of charge, or if made strictly for a charitable or religious institution or society. The making of quotations from a published work if they are compatible with fair use and only to the extent justified for the purpose, including quotations from newspaper articles and periodicals in the form of press summaries, provided that the source and the name of the author, if appearing on the work, are mentioned, and the reproduction or communication to the public by mass media of articles or current political, social, economic, scientific, or religious topic, lectures, addresses, and other works of the same nature which are delivered in a public, if such use is for information purposes and has not been expressly reserved, provided the source is clearly indicated. So kung napapansin nyo, so far, di ba, parang laging sinasabi kung saan nanggaling yung information or yung copyright. Parang we are attributing the ownership to the author or the copyright owner. Okay, going back, the reproduction and communication to the public of literary, scientific, or artistic works as part of reports of current events by means of photography, cinematography, or broadcasting to the extent necessary for the purpose. The inclusion of work in a publication, broadcast, or other communication to the public, sound recording, or film, if such inclusion is made by way of illustration for teaching purposes, and if compatible with fair use. So later on, we will discuss the fair use of a copyright or the theory or doctrine of fair use. So provided that the source and the name of the author, if appearing on the work, are mentioned. So again, we are attributing the work of the author or the copyright owner. The recording made in schools, universities, or educational institutions of a work included in a broadcast for the use of such schools, universities, or educational institutions, provided that such recording must be deleted within a reasonable period after they were first broadcasted. Provided further that such recording may not be made from audiovisual works which are part of the general cinema repertoire of feature films except for the brief excerpts of the work, and the making of apparel recordings by a broadcasting organization by means of its own facilities and for use in its own broadcast, and the use made of work by or under the direction or control of the government, by the National Library, or by educational, scientific, or professional institutions which were such use in the public interest and compatible with fair use. The public performance or the communication to the public of work in place where no admission fee is charged in respect of public performance or communication by a club or institution for a charitable or educational purposes only, whose aim is not profit-making, subject to such other limitations as may be provided in the regulation. So medyo dalawa to hindi pwedeng no admission fee lang. Dapat no admission fee and for charitable or educational purpose. So, kunyari, merong event, ano ba yung mga normal na event? Kunyari, sa SM, di ba, sa SM before, di ba, nagkakaroon ng fireworks display, as may mga band na nagpa-perform. So, using that as an example, for example, wala dong entrance fee. Wala dong entrance fee. Pero, ano ba siya? Pasok ba siya sa wala bang infringement na pwede mangyari doon if someone would sing a song of someone of the other, di ba? Um, Meron. Okay, yung answer meron. Kasi yung event naman sa SM, yung panonood ng fireworks, di ba, hindi naman siya for charitable or educational purpose. So, dapat dalawa. Dapat no admission fee and for charitable and educational purpose. Yun lang yung gusto kong sabihin. And public display of the original or copy of the work that made by means of a film, slide, television, image, or otherwise on screen or by means of any other device or process, provided that either the work has been published or that the original or the copy displayed has been sold, given away, or otherwise transferred to another person by the author or his successor entitled, and any use made of work for the purpose of any judicial proceedings for the giving of professional advice by a legal practitioner. So please take note that the above mentioned shall be interpreted in such way as to allow the work to be used in a manner which does not conflict with the normal exploitation of the work and does not unreasonably prejudice to the right upholder's legitimate interest or his economic interest. So una, dapat hindi ayun nga, hindi siya in conflict sa normal exploitation and hindi mape-prejudice yung economic interest no copyright owner or ni author. So let us now discuss the fair use of copyright. Sabi ka natin twice or thrice yata natin siya nabanggit, di ba? So the fair use of a copyrighted work for criticism, comment, news, reporting, teaching, including limited number of copies for the classroom use, scholarship, research, and similar purposes is not an infringement of copyright. So, to determine whether the use made of a work in a particular case is fair use or ma-apply natin yung fair use doctrine, the factors to be considered shall include the following: the purpose and character of the use, including whether such use is of commercial nature or it's for non-profit education purpose. So, di ba, parang babalik tayo na tawag dito, hindi dapat ma-prejudice yung economic interest ni copyright owner or ni author, 'di ba? So kailangan i-consider natin kung for commercial ba. So if it is a commercial, we can assume na in the absence of contrary, we can assume na mapre-prejudice or magsasuffer yung economic interest ni copyright owner or ni author. The nature of the copyrighted work and the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. So the fact that a work is unpublished shall not by itself bar a finding of fair use if such finding is made upon consideration of all of the above factors. So reproduction of published work. So reproduction of a single copy. So the private reproduction of a published work in a single copy shall be permitted without the authorization of the owner of a copyrighted work where, so unang-una nga sabi natin, di ba, single copy lang, the production is made by a natural person. So natural person lang, hindi pwedeng juridical person, hindi pwedeng corporations. Ayun. And exclusively for research and private study. The permission granted shall not extend to the reproduction of the following. So, a work of architecture in a form, a work of architecture in a form of building or other, form of building or other construction, an entire book or substantial past thereof or of a musical work in which graphics form by reprographic means, a compilation of data and other materials, any work in cases where reproduction would unreasonably conflict with normal exploitation of other work or would otherwise unreasonably prejudice the legitimate interest of the author and a computer program. So with regards to computer program, kailangan lang natin tandaan is pwede siyang for a single copy and yung purpose is for backup and adoption purposes only. So, next would be reproduction by library. So, any library or archive whose activities are not for profit may, without the authorization of the author or copyright owner, make a single copy of the work by reprographic reproduction. When the work, by reason of its fragile character or rarity, cannot be lent to user in its original form. Di ba sa library, basically, nakikiram tayo ng libro para magamit natin. So, kung yung isang libro, sobrang fragile na siya, yung naglalagas-lagas na siya, pwede na mag-reproduce si library mismo ng isa, na yun na lang yung gamitin and i-save, itago na lang yung original published work. Pero madidiscuss pa natin yung kailangan natin dyan later. So, where the work are isolated articles contained in a composite works or brief portions of the other published work and the reproduction is necessary to supply them. When this is considered expedient to person requesting their loan for purposes of research or study instead of lending the volumes or booklets which contain them, and where the making of such limited copies is in order to preserve, and if necessary, in the event that is lost, destroyed, or rendered unusable, replace a copy or to replace in the permanent collection of another similar library or archive a copy which has been lost, destroyed, or rendered unusable, and copies are not available with the publisher. So it shall not be permissible to produce a volume of work published in several volumes or to produce a missing tomes or pages or magazines or similar works unless the volume, tone, or part is out of stock, provided that every library which by law is entitled to receive copies of a printed work shall be entitled, when special reasons so require, to reproduce a copy of published work which is considered necessary for the collection of the library but which is out of stock. So, haba na sinabi niya. So, ang sinasabi lang naman niya dito, di ba, pwede sila libraries on these instances. Pero hindi sila pwedeng mag-reproduce ng single copy kung merong available in the market. Kasi kung may available in the market naman, bumili ka na lang. Pero kung out of stock, pwede. Okay, yun lang yung gist ng madami niyang sinabi. So, let us now discuss the moral rights. So, the author of work shall independently of the economic rights or the grant of an assignment or license with respect to such right have the right to require that the authorship of the work be attributed to him, in particular the right that his name, as far as practicable, be indicated in a prominent way on the copies and in connection with the public use of his work. So, etong una, unlike nung iiba pa, mamaya di-discuss natin, pero etong una, di ba merong term kasi similar with trademark and patent. Etong una with regards to moral rights, eto forever. So this is a right na for perpetuity. Ayun, perpetuity. So it exists, the first moral right exists for perpetuity. Forever. Buti pa dito, no? Anyways, to make any alterations of his work prior to or to withhold it from publication. So to object to any distortion, mutilation, or other modification of or other derogatory action in relation to his work which would be prejudicial to his honor or reputation, and to restrain the use of his name with respect to any work not of his own creation or in the distorted version of his work. So, on the first bullet, dahil gawa mo, pwedeng forever ilagay yung pangalan mo doon, di ba? Because you're the author or the copyright owner. On the last bullet, since you are not the author, you are not the copyright owner, or maybe it is you are the author or you are the copyright owner pero na-distort, di ba? Pwede mong paalis yung pangalan mo. So, sa number 1, pwede mong ipasama yung pangalan mo forever. Sa pangalawa naman, kung hindi mo siya work or kung dinistort yung work mo, pwede mong paalis yung name mo. Okay? An author may waive his right mentioned above by a written instrument. So, hindi pwedeng sabihin niya lang orally. So, but no such waiver shall be valid where its effect is to permit another to use the name of the author or the title of his work or otherwise to make use of his reputation with respect to any version or adoption of his work which, because of alterations therein, would substantially tend to injure the literary or artistic reputation of another author. So, similar siya sa fourth bullet, di ba? Somehow it is similar. And the